Conspiracy and inducing a breach of contract. You're probably wondering why you're going to listen to talk on that, given your respective practice areas and what you're going to gain from it. I appreciate it doesn't sound the most exciting of talks on the planet, but the primary reason for this talk is that I consider it is arguably one of the more underused torts in practice. It does apply quite often. It is perhaps not pleaded or raised as much as it should be, and it applies across the boards of commercial litigation. This is not a tort, or these are not torts that are limited to multi-million-pound fraud claims in the High Court. You do see them, and you should see them in the County Court. As practitioners in commercial litigation, you need to know about them and what to do when they arise. Economic torts in general are not seen that often. There are a number of economic torts. They're not just restricted to conspiracy and inducement. There's also intimidation, interference with the claimant's business, and unlawful means tort. The reason I have chosen to focus on an unlawful means conspiracy and an inducement to breach a contract is because these are the two that arise the most often, and these are the two that I consider to be most relevant to your practices. The classic example of a inducing breach of contract tort or a conspiracy to induce a breach of contract is in those situations where an employee is under a restrictive covenant, quite often not to take customers, to take clients with them for a period of time. That is the one you're probably most familiar with. The risk for their old employer, the claimant, is by the time they realise not only has their employee jumped ship, but in fact that they've taken a hard disk or meta drive of all their customer data, the damage has been done. It's too late for an injunction, or the injunction will be ineffective, and they're left with a claim in damages against an employee who more often than not has not the deepest pockets. The primary benefit of raising and subsequently succeeding in a claim, adding, in that example, the new employer in, is twofold. One, they tend to have deeper pockets than the individual, and two, the claim for damages and the scope for damages is much larger than it would otherwise be in a standalone claim for breach of contract, and I'll come back to that point. But the real reason you need to be thinking about this is because actually there is quite often someone to go after that can not only pay your client damages, but also pay your costs, which will no doubt be quite significant if this case runs its course. Conspiracy, what is it? In simple terms, consists in the agreement of two or more people to do an unlawful act or to do a lawful act by unlawful means. The one that you'll be dealing with in practice is the unlawful acts. And the reason for that is simply because a lawful conspiracy, you need to be aware of it, on the face of it, seems to encompass an awful lot more because it's not restricted to unlawful acts. But it has been described as an anomalous cause of action. And the reason, as it's been described as that, and the reason why it rarely arises in practice, and the reason why I'll not spend any more time on it in this talk, is because of the need to establish and prove that the predominant purpose of the claimant in a lawful means conspiracy is to injure the claimant, injure the party. It is not simply sufficient to establish that it is a purpose or an additional purpose, and the consequence of that in reality is that if a lawful means conspiracy is raised, it is very easy to defend and defeat, because all the defendant needs to demonstrate is that they had a belief in a legitimate aim, and the test for legitimate aim is not high. And the obvious example of a legitimate aim is, well, I was seeking to bolster my own business, I was seeking to raise revenue, etc., etc. Seeking to bolster one's own business or seeking to raise seeking to raise revenue is not the predominant purpose. If one is, going back to the example of stealing confidential data from an employee under a restrictive covenant, that is not the predominant purpose. The reality is if you're only relying on this as your cause of action in a claim, you're in the territory of the village of the damned, and I'd be very cautious of proceeding. The one that does arise and will arise in practice more often than not, and really the focus of this talk, is an unlawful means conspiracy. What actually is an unlawful means conspiracy? What does it require? Is it an unlawful means conspiracy requires 1, a combination or agreement between the defendant and one or more others. 2, an intention to injure the other party. 3, unlawful acts carried out pursuant to that combination. And 4, damage and causation. And the best authority on this is the Racing Partnership and Sports Information Services. That deals with gambling and is another reason as why one should not gamble, because it shows the danger of it when live betting information was illegally passed from one party to another. The important point from that case, and the important point that you need to recall and have at the forefront of your mind, is the 4 key elements here. Is there an agreement? Is there an intention to cause damage? Is there an unlawful act? And is there damage as a consequence of that? That's it in a nutshell. Easy peasy. What can go wrong? Why is it not raised more often? Well, let's look at these tests in a little bit more detail. An agreement is not a particularly complicated area to examine. The key point in respect of an agreement is that there is no requirement for an express formal agreement, nor are you likely to ever see one in practice. It has been held that all that is required is a combination and a common intention between the parties, and the agreement can be implied. Ultimately, what you need to show is that there are 2 parties who are acting in concert with each other at the relevant time. They must be aware of the surrounding circumstance, and they must share the same object, which is to injure or damage the other party. The agreement aspect of this isn't difficult to define in legal terms. The difficulty arises in evidencing it in practice. I'll come back to that towards the end of this talk. Intention. I confess, when I was looking at these slides last night, it took me a minute to understand the hospital bed. But the reason for that image is because it reflects the need of the intention to injure the claimant. Unlike a lawful means conspiracy, which you will recall the predominant purpose of the agreement is to injure the claimant, the only requirement in an unlawful means conspiracy is that it is a purpose of the agreement to injure the claimant. Thus, best illustrated by the situation where a defendant intends to advance their own economic interests. Again, using that example I gave in the lawful means, well, I'm going to raise revenue in my business by making use of these customers that are subject to restrictive covenant. In a lawful means conspiracy, that wouldn't work. In a unlawful means conspiracy, that would work, and that would be sufficient to demonstrate an intention, because one's gain ultimately corresponds to another loss, and the fact that there is a gain to the claimant here is sufficient on the basis that there is a loss and a purpose to injure the claimant. What has been referenced in case law and the key authority in an unlawful means conspiracy that's worth reading in full is the decision of Lord Hoffman in OBG Limited and Allen. That was and remains the leading case in this area. The key point in that is the intention that you have to demonstrate and you have to have when advising a client, that they have to evidence is that there was an intention of the parties to injure the other party. That's it in a nutshell. Intention and knowledge in this area often overlap and are often interlinked. They go hand in hand, and quite often if one establishes that the defendant intended to cause some damage, it will be easy to demonstrate that they knew that they were going to cause some damage. And the question that has been raised and dealt with is the question of, do they actually need to know, does a party need to know that they're going to be acting unlawfully? No is the short answer. They do, however, need to know the facts that would render the conduct unlawful, and there's a key distinction there. You need to know, to use that example of a restrictive covenant, you need to know that there is a contract in place, but one does not need to establish that. The conspirators needed to understand that if they were going to procure the list of employees, or they were going to procure the list of clients under the restrictive covenant, that would amount to either a breach or unlawful conduct. That is a crucial and subtle difference between a party being aware of the existence of the term and knowing that the consequence of acting in breach of that term is unlawful. And that is probably the critical distinction between an unlawful means conspiracy and an inducement. And arguably, on the face of it, serves to render it easier to prove a unlawful means conspiracy on the point of intention and knowledge, because as you will see in respect of an inducement, the defendant's subjective state of mind is relevant, and whether they held an honest belief or not. That is not the case in a unlawful means conspiracy. Right, what constitutes an unlawful means or an unlawful action? Well, there's some examples there. The key point here to emphasize is that this is not restricted to a breach of contract. It is not restricted to the classic example of a restrictive covenant. It includes and concerns threats to break contracts, procurements of breaches of contracts, criminal offences, breaches of fiduciary duty. The scope of this tort is wider than the scope of inducing a breach of contract. And this is probably the area where I say actually quite often it's overlooked in practice, because when people see evidence of unlawful acts and think of adding in or joining another party, they're quite often fixated on the idea that we need to establish a breach of contract. In an unlawful means conspiracy, all you need to establish is there unlawful action? And the threshold for that is not particularly high, and it does lead to wider claims than would otherwise be the case in a straightforward inducing breach of contract case. Damage. If you get this far, you're in good territory, because once we get to damage, and this is the final hurdle that the claimant needs to overcome, is the damages, as I've already alluded to, are going to be wider than a standard breach of contract or tortious claim, which you will all know the clear principles there. And the reason for that is damages are assessed at large. What that means in practice is a claimant does not have to establish a specific and precise calculation as to what the defendant's actions have caused. And examples I've given in the notes from, I was going to say recent case law, one of the examples is about 70 years old. Costs of investigating the conspiracy, so the actual, not the legal costs themselves, but the actual costs of looking into the conspiracy are recoverable. The costs of loss of profits are recoverable and tend to be wider. And also in circumstances where the damage is so great to cause damage to the claimant's business that has resulted in business being lost, those are also recoverable, and the scope for damages in these claims is significant. It is wide, and quite often it encourages parties to get together early and resolve these through some form of ADR. That being said, the principles of mitigation do still apply. So it's not the case of once you've got a client in your office and you're clear that they're going to win, you can say, right, go off and do what you want and you'll get all this money back. They still need to be under a duty to mitigating their loss, but not being limited to a precise calculation, not being qualified by standard contractual costs, can, does, and will make a significant difference to the outcome if you get as far as assessing your damages in front of a judge at court. One warning to note in respect of conspiracy claims, and that concerns fraud. Firstly, there is a distinction to make between a fraudulent claim and a conspiracy claim. One does not require the other. Dishonesty is not a prerequisite to establishing a conspiracy claim. As you will have seen from those previous core elements, dishonesty is not required to be proved, and therefore you do not need to plead a fraud when pleading a conspiracy. However, where dishonesty is alleged, and more often than not it is alleged and is involved, the fraud requirements that are attached to pleading fraud, which as set out in the Chancery Guide, which you will all know off by heart by now, do apply, but nonetheless they are worth repeating. Firstly, pursuant to paragraph 8.2 of Practice Direction 16 and paragraph 4.8 of the Chancery Guide itself requires a claimant in a allegation of fraud to set out full particulars of any allegation of fraud, dishonesty, malice, or illegality, and secondly, where any inference of fraud or dishonesty is alleged, the facts on the basis of which the inference is alleged. That second requirement is important because quite often you are going to be relying on inferences in these cases. It's rare that you have documentary evidence that you can simply point to and plead demonstrating the agreement or the intention or the knowledge. The other requirement is, as you'll be aware, that a party should not make allegations of fraud or dishonesty unless there is credible material to support the contention made. Setting out such matters without such material being available may result in the particular allegations being struck out and may result in a wasted costs order being made against the legal advisors responsible. That is a critical warning that you need to have in mind. You, not the client, could be the subject of a wasted costs order if, after listening to this talk, you go and start pleading fraud in every case next week. And be conscious that you may find yourself at not only at summary judgment and strikeout application, but also wasted costs. But those principles in terms of the particulars, the facts on the inference, and the credible material, not only do you have to have in mind when thinking about pleading your claim, if you're pleading it yourself, it's also incredibly useful to have these in mind when you're advising the client at the outset. That is what you need to think about. What is going to be written down in these particulars? What are the particulars? What is the allegation of fraud? What are the facts that we say we can show to demonstrate? And what is this credible material that we have? You now know the law. You now know that you need to establish an agreement. You need to establish an intention to damage. You need to establish an unlawful act. And you need to establish that there's damage. You've got the law. You know what to plead. You know what you need the client to demonstrate. If you get that right, you'll not go far wrong. So I shall quickly deal with the second of the economic torts in this talk, and that is one that I suspect most people are probably more familiar with because it arises more often in practice, and that, as you will see, is the tort of inducing or procuring a breach of contract. These are often pleaded interchangeably, often pleaded together. There's nothing wrong with that. We see inducement more, even though, as I've alluded to, there's arguably more scope for an unlawful means conspiracy claim. What is the difference? Well, before we get to the difference, let's look at the actual ingredients of an inducement claim. Similar to conspiracy, it's often known, and some of you will probably refer to this as the Lumley and Guy tort. The essential ingredients are where one person intentionally induces or procures a second person to commit a breach of contract against a third person, so that third person suffers damage. So we've got breach of contract, inducement, knowledge of the contract, intention again to procure the breach, and finally, unlike conspiracy, there is the potential of a defence, and that defence is whether the defendant can establish that they have a lawful justification for inducing the other party to breach the contract. That's something you need to be aware of. The case law, and I'll come back to, but that quite often involves trade unions acting, or certainly thinking that they're acting in lawful justification to persuade their members to breach contracts. But it's there, it's not there, albeit not on the face of it, on an unlawful means conspiracy. So examining those requirements in more detail, breach of contract is pretty straightforward. You all know what a breach is by now. The inducing, procuring part of this tort is something, words that are used quite often in practice. The definition is, I consider to be important, and this is what you need to have in mind, because quite often your client will not necessarily understand what inducing or procuring actually means. Well, the definition, and the word that's repeated in the definition of both inducing and procuring, is persuading. And that word's important because there is a dividing line between facilitating a breach of contract, allowing a breach to happen, and actually procuring or inducing it. In other words, is the defendant actually taking action to persuade the other party to breach the contract, or are they simply standing back and allowing that breach to happen? And I've quoted from Lord Hoffman's decision in OBG again, which is a useful quotation stating there is a crucial difference between cases where a defendant induces a contracting party not to perform his contractual obligations and cases where the defendant prevents a contracting party from carrying out his contractual obligations. Again, it's a fine line, but the core behaviour of an inducement is the act of persuading a party to break the contract. Where there is mere facilitation or a failure to take action, one of the other economic torts may arise. We don't have time to cover it this morning. That's the tort of causing loss by unlawful means. Similar but distinct to a conspiracy, an unlawful means conspiracy. The difficulty with a tort of causing loss by unlawful means is that you need to establish the behaviour is unlawful, but it's there to be aware of in circumstances where there's evidence of a breach of contract, but there's not necessarily the evidence of the party actually persuading the other party to break the contract. Knowledge is the million-dollar question, and where these cases are quite often fought, certainly on inducement. The key issue in knowledge is that you must be able to demonstrate that the party knows they are procuring a breach. Contrast that with the unlawful means conspiracy, where one does not need to establish that the party is acting unlawfully. A party must intend to cause some harm. So there must be knowledge of procuring a breach and an intention to cause some harm. So in short, what do you need to establish that the defendant or the party inducing the breach of contract actually needs to know in practice? Firstly, they need to know of the contract. That's trite. Secondly, they need to know that they are in fact inducing a breach. Do they need to know of the specific terms, and do you need to prove that they have read, considered, analysed the terms? No, but only if they have deliberately disregarded the terms. And that is the blind eye knowledge test. And the key test in blind eye knowledge cases, which are the ones that arise quite often, is, has there been a conscious decision not to inquire into the existence of a fact? Difficult to prove in practice, but what you're really looking for, and the easiest step to take in practice, as soon as there's a suggestion that there's going to be, or there is an inducement, is send the inducing party the contract. If they then disregard it, well, that's on them. That is a conscious decision not to inquire. If they don't have the contract in the first place, and if they're not aware of it, you're in more difficult territory. And the reason for that is it's simply insufficient to argue and rely on the fact that a defendant should have drawn inferences a reasonable person would have drawn. So in other words, it's insufficient to simply say, well, in certain industries, energy brokers, quite often the ones that have been litigated recently, it's insufficient to say, well, they must have known that the employee was under a contract, and they must have known that contract had a restrictive covenant, and they must have known that that covenant would have lasted 6 months. That's not enough. That's not a good enough inference to draw. The other issue, and this is where inducing cases are difficult in practice, is the defendant's state of mind is relevant. And that's relevant both to knowledge and intention. I'm not going to embarrass my colleague who was unsuccessful in the Court of Appeal in the case of Allen and Dodd. He made a sterling effort to try and persuade the Court of Appeal that the defendant's state of mind wasn't relevant. The Court of Appeal disagreed, and the issue in that case was that the defendant had actually got legal advice to say on balance, or certainly sufficient advice to persuade the Court of Appeal that they didn't have the necessary knowledge or intention to procure a breach of contract. And a further example, a more recent example of that, is when a defendant established that they honestly believed they were entitled to induce the breach. And it was held that knowledge element of the tort is satisfied if the defendant was or should have been aware of the essential facts that amount to a breach of contract, including the material terms of the contract, even if he was not aware of the applicable rules and principles of law. So if a defendant turns around and says, well, I spoke to my solicitor, I spoke to a barrister, and I got clear advice that what I was doing was entirely lawful and accurate, and you may find yourself in some difficulty in court. Means, ends, and consequences, that's the intention, and that was succinctly summarised by Lord Hoffman in OBG. Ultimately, it doesn't matter if the breach of the contract is a means to a different end. That is still sufficient for inducing a breach of contract. It doesn't matter if the breach is the end in itself. It does matter, and it is a distinction, if it is only a foreseeable consequence. The party must intend to procure the breach as an end in itself or as a means to achieve some other end. They cannot be liable if they're simply procuring a breach and it's only a foreseeable consequence of their action. Damages, I can be brief on this because this is another similarity with unlawful means conspiracy. There was a recent decision by the Court of Appeal in Northumber PLC and Genie World effectively confirmed that it doesn't really matter at the conclusion as to whether it was unlawful means conspiracy or inducing contract. Damages were going to be assessed on the same basis. They were at large and they were significant. Defensive justification, as I've indicated earlier, there is a defensive justification in inducing breach of contract. Something you need to be aware of. There's conflicting authority as to whether it is also available in an unlawful means conspiracy. If this was going to be argued at the Court of Appeal, I would bet on the Court of Appeal indicating that it's likely to be available in an unlawful means conspiracy that in reality is a breach of contract case. So where it's pleaded as well as inducing a breach of contract, it's unlikely to be available in other situations and unlawful behaviour that stem beyond breaching a contract. It's something, however, that you need to bear in mind when inducing a breach of contract is raised. What are you actually looking for in practice? Evidence. There is no silver bullet in these cases. It will be a rare case where you find an email, a document, a contract, a written agreement between parties saying, let's go and breach this contract together. So what are you actually looking for in terms of evidence? Quotation I've included suggests that it is a rare case where there is evidence of an agreement. It will be necessary to scrutinise the acts relied upon in order to see what inferences can be drawn as to the existence or otherwise of an alleged conspiracy or combination. That is effectively your job when these arise. You're not looking for you are looking for a written agreement. You probably won't find it. You're looking to establish an inference. An inference is sufficient, but you do need evidence to support it. And the reason for that is not only for the cost consequences, but also that it's been held as a serious tort. It requires clear evidence, and therein lies the difficulty with these claims in practice. The law is reasonably straightforward. Establishing the evidence is the sticking point. If you come at the other party with fraud, you better win. And the reason for that, although there's no presumption that costs will be assessed on an indemnity basis, and there was a recent authority of this Tacker and Meekan, the appeal judge in that effectively said the trial judge wasn't wrong to find that there was no presumption and wasn't wrong to award indemnity costs, but I would have awarded indemnity costs, and it simply didn't meet the threshold of an appeal. The reality is, if you start alleging dishonest conspiracy or dishonest inducement cases and you lose, whether your client is subject to an indemnity costs order or a standard costs order, they are going to be paying a significant amount of costs. That is the risk in these cases. The law is straightforward. The evidence is difficult. If you get it wrong, they'll be paying a lot of costs. So drawing this all together, what do you do in practice? Well, just remember what Mr. Jagger said in Great Expectations. If a client comes to you and says, it looks as though this business is involved, what do we do about it? Say, well, take nothing on its looks. Take everything on the evidence. There is no better rule. And I would say that arguably applies to any claim in commercial litigation, and in fact, any claim in England and Wales that requires evidence. You will have evidence there. It's sufficient to base it on inferences. Be aware of this. Be prepared to raise it. It is a useful tort. It's not restricted to high court multi-million-pound claims, and it's something that can have enormous benefits if you are successful.